Hello, my true crime lovelies. How are you? I hope you are well. I have missed you. I was a little under the weather, but I'm here now. And speaking of weather, it's nice and sunny here in Manhattan. It's a little humid, but not like it's survivable. I'll say that. It's not like oh. So I hope the weather is nice wherever you are, whatever time it is, whatever's going on. I hope all is well. Okay, let's get into this because y'all saw the title. Sarah Boone, Unhinged. I think her mind, I don't know if it's possible, is deteriorating. Like maybe the wine and the alcohol, over the period of time is finally kicking in and it's taking out brain cells. Because I will say this is probably one of the most nonsensical letters that I've seen from her. And I don't think she did it alone. I think the Delphines are still helping her. Let me show you the receipts I have. But first, we are going to thank the members. So I'm going to play the intro and I'll see you on the other side. All right, as promised. First, we're going to get into, oh, you can't see that. Let me move myself over to the side for a second. So this is the letter. This is an envelope. You'll notice there's no postage on it, right? So this obviously did not come from Sarah to Orange County because it would need a stamp or some indication that it had been through the post office. But that's not the really weird part. The weird part is if you look at it, she's sending it to Orange County Clerk of Court, Division 20, which is District 9. That's where Judge Koenig is, right? But she calls herself the appellant. In that court, she is not the appellant. In that court, and I will show you, she is the defendant. Shout out to Susan Auber. You see this here? This is criminal court, Judge Michael S. Koenig, Sarah Boone, defendant, attorney Joshua Adams. So that's the first sort of like, wonder what she's thinking. WHINE, that kind of wine. That's what's happening. She's done. She can't have the other wine, but yeah. Welcome to the Boone's farm, or welcome back. Okay, so then this is why I say I think the Delapines are still helping her. You'll notice. So this was first postmarked in Reading, Connecticut, on June 30th. Well, who's in Connecticut? Half of the Delapines, Julian Delapine specifically. But it's part of, so if you're not familiar with this part of the eastern United States, it's the tri-state. So it's New York, Connecticut, Jersey. So we're kind of glom together. Although I will say whenever someone lives in Connecticut or Jersey and they work in New York, they make sure to mention that they work in New York. Hands down, everybody I've met. So Connecticut, right next door. So then it goes over to Westchester, New York on July 1st, right? So it's making its way down to Florida. I suspect they thought this might be on the internet because you'll see they blocked out the tracking number. I feel like 98% certain that the post office didn't do that because then why would they have it? I mean, the post office can still scan here, which is why I think it was the sender who did it, knowing that the post office can just bloop, read that barcode. Because if I had this whole number, honey, I would be on USPS.com looking at the exact address that this originated from. So that's why I think the Delphines are still helping her. Do I think it's doing her any good? Absolutely not, because the ridiculousness ensues. Let me go back. I made this too big now. Why is it not letting me? There we go. Okay, so let's go through this. Now you'll notice this didn't get there to the clerk until the 8th this was filed in. And also, I wonder why she sent the envelope to the Delapines, and I'm suspecting she sent more than one. I'm thinking we're going to see a few more filings. I was expecting her parenting plan because that's overdue. Or at least due. I was expecting her pretrial conference, non-conference, because Brian's team didn't want to meet with her, but her expectations of what she wants from the child. She was admonished last time that they were in family court by the judge saying, "You're late, ma'am. Yes, I'm going to admonish Brian for not meeting with you or not coming to the court saying they weren't going to meet with you. But you are overdue. So get this in." And then, so parenting plan, the pretrial, what she wants, and then her financials. She would promise to send in the typed out version. Remember her motion for the judge to accept the handwritten motion or the handwritten financials? In that motion, it said the other one would be forthcoming. Well, it is July 9th, and girl, where is it at? Anyway, so this came through on the 8th, and here's what it is. What it is. So now here she's corrected herself. She's back to being a defendant, and the state of Florida being the plaintiff. Notice of inquiry. She doesn't address it to anyone specifically. Comes now. So who are you inquiring of, Sarah? Because this is one of those things like in an office, if people are like, it don't got my name on it, it might just sit there. But you know, maybe that's just the offices I've worked in the past. Sarah Boone, appellant, and respectfully comes now. Sarah Boone, appellant. So now she's appellant. Up there, she's defendant. On the envelope, she's appellant. She's got identity issues. And respectfully moves this honorable court to please provide status of her court-appointed appellate attorney, Joshua E. Adams, Esquire, in addition to her inquiry as to the status of her pending appeal. So nobody in that court is responsible for telling her the status of that appeal. And whoever in Connecticut mailed this for her could have called the appellate clerk of courts and gotten this information. There was no need to send it to Orange County. In support, the appellant states the following. An order was filed with the Ninth Judicial Circuit by the Circuit Court, Judge Michael S. Kranig. Zaddy Kranig, hey. Court number 2, court-appointed appellate counsel Joshua E. Adams has sent a single basic introduction via inmate messaging to appellant on February 27th, 2025, asking if she had any information and to not hesitate to contact him with. So now she has just breached the attorney-client privilege by sharing what they have discussed, specifically what he asked of her. 3, appellant has attempted, or she hasn't breached it, she's broken it, like all bets are off. Appellant has attempted to contact Mr. Adams via inmate messaging 5 times. She doesn't give dates or times, so we know Sarah, we've seen her tablet messages. That could have been on a Saturday morning, 8:05, 8:06, 8:07, 8:08, 8:09. Do you know what I mean? Like, you have no credibility, ma'am. You need to back this up with some facts. And sent 2 handwritten letters to his office in efforts to receive status of her appeal. Again, I'm going to show you guys so nobody thinks I might be nitpicking anyway, but it's all up on, here we are, Florida appellate case information. It's all here, what's going on with the status. So it's been a busy year. I don't know why she needed to call him and ask him what was going on. As far as like just the status of it, right? So order to serve brief was served on 6/13. A lot of people reported on that. I intentionally did not because I was like, I'm not tipping off the flying monkeys if they don't know. Let it pass. Let that day pass. But of course, the internet was all abuzz, and one of the flying monkeys got in touch with her attorney, I'm sure, and sent that. So her attorney on 6/24 filed for motion for extension of time to serve initial brief, which we did cover that because at that point I was like, it's already been done. And then on the 1st of July, order on motion for extension of time to serve initial brief. So that was granted. Motion for extension of time is granted. I think this is what I covered, and then I looped in all the other ones. The appellant shall serve the initial brief within 60 days from the date of this order. So July 1st, we'll just say roughly September 1st. A little more, a little less, because I think August has 31 days. So it might be August 31st, but just let's keep it even. September 1, the brief has to get in. So now I know what you're saying. They mailed it on June 30th, so they couldn't have known about this. Yes, but they could have seen, if we go back, right? They could have seen that on 6/24, the motion for extension of time to serve initial brief was filed. And then therefore Sarah would have known the status and they could have saved $10. But you know what? Support the US Postal Service. I understand they need it. Okay, back to this. So to present date of this inquiry, appellant has not received any type of response or correspondence in any form or manner. That is like so many extra words. In any form or manner, any type already covered it. So we get it. He didn't send it via pigeon courier or paper airplane. He hasn't not contacted you. I think if you just say he has not contacted you, we get it. Nor has any of her 9 third-party flying monkeys, I mean representatives, on her behalf via email and phone calls, which go directly to his voicemail. Okay. If you call me on my mobile, it is going to go to my voicemail too. I mean, it's very rare that I'm just, first of all, I feel like, and this is a whole rant about our society, people expect you to be available like in a second's notice, like a text. They want to response back in 60 seconds or a phone call you answer. Even like, I have an attorney for another reason. I contacted them and I had to tell them, please stop calling me because I'm at work. Like, I have a lot of meetings. We can schedule a time. It's not that I don't want to talk to you on the phone, but don't think that anytime you call at any moment, I'm just like, hey, what's going on? No, I just don't have that kind of life. So she says, like, going directly to voicemail, like it's a sin and a shame. Honey, that's normal. Ongoing 7, so we know she definitely had a hand in writing this. Ongoing 7 months, appellant has received 1 message from her court-appointed appellate attorney, Joshua E. Adams. Oh my God, the extra words. Appellant was recently made aware by a third-party flying monkey representative that the court issued an order on June 13th with a 20-day due date requiring an initial brief be filed on or her appeal may be dismissed due to the complete lack of proper and effective communication from her court-appointed appellate attorney. The appellant's appeal is now in jeopardy. Again, hyperbole. Due to the complete lack. It's not a complete lack because you said he contacted you once. Proper and effective defined as, she's real worried on proper. Little Miss Stinky, starchy, from body fluids, pink shorts, drinking from a fire hose, or not a fire hose, drinking from a water fountain. She might as well be drinking from a fire hose, drinking from a water fountain that has no hose. Like, she's real worried about proper, right? The failure of an appointed attorney to perform duties or communicate with their client cannot be held against the appellant. So he hasn't failed to perform duties. He's filed the motion for extension. It's been extended. So what is going to be held against you? And again, they would have seen this because he filed it on 6/24. So when they sent all of this out, they had the ability to go on that website and see this, they being the flying monkeys. Dismissal of an appeal under these circumstances would be an obvious denial of her due process and effective assistance of counsel. And the lower court cares why. You think Judge Kranick went to law school for 3 years, ran for judge, served many years as a judge to hear about your ineffective assistance of counsel or alleged? See Pullen v. State. The failure of appointed counsel to act cannot be imputed to the defendant to justify dismissal. Okay, we got it. I would think the appellate court would want to hear that, though, since what can Kranig do? He's going to call the appellate court on your case, on your behalf, and say, oh, somebody I convicted of life without parole has notified me that their counsel hasn't, and she's worried about a dismissal. Like, that doesn't even sound logical. And even if Sarah's brain is wine pickled, what about the flying monkeys? Y'all don't know the difference? Appellant further invokes Douglas v. California. So she cites a couple California cases. I actually had to look this up because I thought it was odd. You can have citations from other courts, but these don't. It has a lower ranking than if she had filed or if she had found in Florida, but whatever, which outlines the duty of appointed appellate counsel to support the appeal or withdraw following proper procedures, neither of which have been followed here. So what hasn't been followed, Sarah? Which outlines the duty of appointed appellate counsel to support the appeal or withdraw following proper procedures. So he is supporting the appeal. He filed the extension on the 24th of June, and he has until September 1st to file for the brief. He filed the motion to extend the delivery of the brief. Appellate respectfully requests this honorable court to please advise and take notice of these violations. Take notice for what? This is the dry begging, right? Are you asking Judge Kranig to give you another lawyer? She doesn't want to say that, right? Because then if people are like, you fired a lawyer again, I never asked for him to be fired. It's that like pedantic circular conversation that she likes to have, right? It's dry begging. This is textbook dry begging. Take notice of these violations. So she's like putting him on notice, right? If I have to write you again, what are you going to do about it? Why is he taking notice? Why would he care? And to either compel court-appointed appellate attorney to fulfill his legal duty. So by the time he's received this, Kranig, this is moot, is why I'm saying, like, why would he care? The dude has done his job. Joshua's done his job. To fulfill his legal duties and communicate immediately, or appoint new counsel capable of necessary communication and representation and inclusive of the appellant. So she's not saying fire him exactly, but she's saying appoint new counsel. Unfortunately, I mean, and we discussed this from the very beginning, the appellate attorneys does not have to communicate with her in the same way, that she wanted all the others. I mean, we know even like from Patricia Cashman and Bankowitz, all those guys, she wanted an excessive amount of attention and communication. I think in Patricia Cashman's filing with JAC, Sarah had like multiple pages of correspondence where Patricia Cashman was like, she had to read a 58-page letter. She had to read a 28-page letter. It's a lot. Like, attorneys don't have that type of time, and especially attorneys with a caseload. Like, maybe if Sarah had $1 gajillion and could pay for an attorney to drop everything and just dedicate their time to her, maybe that would be enough. I mean, we'd have to ask Owens. He did that at his own expense and bought her clothes and put money on her books, and she still threw him under the bus at the end of the day. Like, she's never satisfied, like that Prince song. She's never, you get it. But you know what I mean? I don't understand this logic. And again, I feel like her priorities are misplaced. Ma'am, you have a family court date coming up and you have deliverables that are either due or overdue. Your financials, that the typed version is definitely overdue, and you should resubmit it with the truth, right? You have people who have sent you money in 2024, yet on your financials, you say you've received zero money. We've gone over those receipts in another video. I'll link it. I think I'll link it over here. I'll link it somewhere. And then where is your parenting plan? Where is your pretrial, what outcome you desire when the case is heard? So like focus on what matters and find, I guess, better flying monkeys who are better at research and diligence. I bet you're missing Lana now, right? Um, because your new helpers are not up to the task. They're not good at looking up information. But maybe you guys are pretending that your brain is wine pickled in order to tolerate Sarah. I don't know. I don't know what's in it for you. But your horse is losing. She's not, like, nobody's betting on her. Nobody's betting on her. All right, you guys. Oh my goodness. Can you believe it? Just the whole it's given hot mess. All of it is giving hot mess, desperation. You have a very slim chance. Like, I don't think Sarah's going to get anything out of the appeal if it moves to, like, I think it will be heard. I hope it will be heard. Like I said, I would like for it to be codified, like what Kranik did with the waiver slash forfeiture. But I don't think anything will come about in Sarah's favor. Like, do I think she's getting resentenced? Do I think she's getting a new trial? Absolutely not. I think Kranik ran a tight ship, Zaddy Kranik, and I think Judge Jackson is running a tight ship so far. So I don't know why Sarah's slacking on all this paperwork that is related to the case. That's for all the money. And then I wonder too, are the Delapines like still hoping she's going to get this money and they're going to use that to fund the documentary? In Peter's email to me, he was like, "Oh, I helped her in the beginning out of basic humanity," but he didn't mention sending a check to George's son for basic humanity. Um, so yeah, what's clearly still involved, despite his protestations in the email to me, clearly still involved. Um, for what reason, time will tell. Balls of a burglar, all of them, the lot of them. Balls of a burglar. Someone asked me what that meant. Like, you have cojones. Burglars go into people's homes, their private spaces, and take their private things. Like, that's not a normal thing. You have to have some cojones to do that, because you could get your head blown off. Anything could happen. You're in somebody else's house, so that's what that means. Um, for those who keep asking. All right, let me know your thoughts. Am I being too harsh on her? Did I come back from my illness like extra snarky? Do you guys think I should cut her some slack? Let me know. I'll talk to you down in the comments below. Toodles.